SJC-13171, Commonwealth v. Christopher D. DeJesus.
Attorney Hagar? Is that
Yeah.
how you say it?
Yes, Hagar, yes, sorry,
Great.
thank you. Good morning, Mayor. Pleased to call Mr. Hagar for Mr. Jesus. We have a couple issues on appeal. I'll deal with the suppression issue first. Regarding standing, we have a situation, both crimes involve possession. Two issues outstanding. One is the search happened at the time of the crime. The individual was present on the premise at the time of the search, which we have in this situation. He was on the porch inside when police arrived, and he was on the premise at the time the police conducted the search. I'd also point to the Franklin case, where a point of estoppel, where the Commonwealth even put the defendant.
I'm
Yes,
sorry,
sir.
Attorney Hagar, can I just ask you to slow down just a little bit?
Okay.
And then just before you go on, can you just tell us why we should consider the curtilage argument?
Oh, yes, the curtilage argument, yes.
Why should we think about it at all, since it wasn't raised at the appeals court?
Oh, the waiver, yes. As I cite in our brief, Your Honor, you can certainly view arguments not raised below, so long as the record is sufficient to have a filing of the curtilage, and if you slow with the standard. So the record here is sufficient to show that the cellar was part of the curtilage of the home. And also, there's if the evidence is suppressed, there's insufficient evidence which creates a substantial risk of miscarriage of justice, and that's enough to view the waived argument, and that it should be reversed. So that's the reasons why it was waived.
So you're saying just
Yes.
if there's a substantial risk of a miscarriage of justice, we should look at it regardless of whether it was raised at the appeals court?
Yes, case law on point that if the record is sufficient to make the argument, which it is here, and insufficient evidence equates substantial risk of miscarriage of justice, therefore you can review it.
But is that like your secondary argument if the first one doesn't go forward?
Basically, there's no evidence, so certainly certainly harmless error, but certainly at a minute, it's also created a substantial risk of miscarriage of justice. So we're both present here, and even though it's made being waived, you can still review it insofar as I just stated. Standing.
On that issue, it wouldn't be reached if the theory is that he was not alleged to have possessed the firearm at the time that he was on the side of the house, that the time of possession was the time in the snapshot.
Yeah, well, if he's present, Amendola and automatic standing, we have possession of a crime. Both charges, the defeating device and the firearm, have an element of possession. So
Wait. Did you say if he's present?
Yes, he's
But
present.
that's not my understanding of Amendola.
Right.
My understanding is that if he's charged with a possessory offense, he has automatic standing whether or not he is present. That's what I thought Amendola said.
Amendola, the overall policy of Amendola is you need to show that the individual that search happened in a conscious sense. And also Amendola states that.
Counsel, can I ask you again to slow down? It's just really difficult for me
Okay,
to understand
Sorry, Your Honor.
given the mask and the speed at which you're
And you
speaking.
know you can take off your mask if you want.
Well, I'm not vaccinated, I'm sorry, Your Honor.
I'm not saying you want to.
Okay. Yes, Your Honor. So essentially, Amendola stands for the principle that you don't want to put the individual in a dilemma of self-incrimination. And here he's here with the police the night at 10:30 at night. He's being held by the police. He shouldn't be forced to say, that's my firearm. So the general principle of Amendola automatic standing is to prevent the defendant being in a dilemma of self-incrimination or be impeached at trial. But certainly he's present. The Franklin case is pretty much on point regarding presence, and that the individual, prior to the event, shot a firearm to his girlfriend. Police arrived later on. He was
I'm
still.
so sorry. Did you say you're not vaccinated?
I'm sorry, what?
You say you're not?
Yes.
Okay, so you do have to
then
wear
you
your
gotta wear
mask.
your mask,
Oh, yeah, I'm sorry.
So anyway, so the Franklin case, the individual was still present on the premises when the police arrived. He was not in the exact location, he was in the adjacent room, but he was on the property. So the Franklin case is pretty much on point in the principle that if he's present on the property, if he is standing and challenge the search.
Well, counsel, I'm just trying to follow your progression. You keep saying that Mr. DeJesus was on. He wasn't there. There was a factual finding by the court that he wasn't on site. He was next door at 4. I believe it was number 4. Whatever the name of the street was. But you keep saying he wasn't. Where's your support for that? He was there at number 14.
He was on the porch in the side yard when the police arrived. And it's not a factual finding, it's really an argument, presence is a legal argument as much as a factual argument.
You are really hard to follow. Could you slow down and enunciate a little more clear?
Yeah.
Because we're going to lose your whole argument.
The presence is also a legal argument, and the point is he's actually there. And he was present on the premises when the police arrived. He was on the porch in the side yard. And then when the police exited the cruiser, he started to walk away, then they
Right.
detained him. So I would argue that he's present on the property. I'd also argue that Amendola, an automatic standing comes down to the issue of you don't put the defendant in a situation where he has to self-incriminate himself.
Okay, I
And
follow you.
that's the overlying principle. I'd also argue that on the Franklin case, that when you have a situation where the Commonwealth takes a position that he's present on the property, which it did at closing argument, they're not allowed to flip-flop and use from a stopper standpoint, argue something else at the motion suppression hearing. So Franklin stands to the point from a fairness standpoint. If the Commonwealth takes a position that he's present on the property to support the investigation, they cannot use the other argument he's not there for motion to suppress argument. I'd also argue I might do a 16L letter. There's also a possibility of target standing, where he was the target of the investigation, the Snapchat video, and I would argue it's egregious conduct by the police to show up there with 20 officers at 10:30 at night and chase people into the cellar. And also it's the overall principle of Amendola, of the exclusionary rule, is that it's not fair to not give the opportunity to challenge the search, and that police activity here, I think was egregious, and the exclusionary rule should apply to allow him to have an automatic standing. In regard to the curtilage argument, expectation of privacy, this is a home, and therefore he has two ways of challenging the search. One is to show the area as part of the curtilage of the house, and in parallel to that, he can show that somebody, one of the tenants or landlord, had an expectation of privacy in the cellar. They're mutually exclusive, they're side by side, and contrary to the appeals court decision, expectation of privacy does not supplant the curtilage argument. Curtilage is tied to the home, and it's a separate and parallel argument he can make. Regarding the curtilage, looking at the Dunn factors, proximity and enclosure, the cellar was below the three apartments, connected by a stairway, so certainly proximity and enclosure was part of the home. Regarding nature of use, if you look back at the motion suppression hearing, there was likely about two laundry rooms, there was tables, there was chairs, there was benches, there was bureaus, there was a couple of locked storage areas. The tenants used the area to have the guests down there by evidence of the video. So the use is almost like an extension of the house, almost like a living room, or man cave, if you will. So given that being said, that certainly that nature of use was one in which the area was used as if life extends, and that they use the area as if it's a living room, entertainment, laundry, and storage. Regarding protecting from observation, it's a cellar. The cellar was in the foundation. You had to go down below grade, a flight of stairs to get downstairs. The door was in the back of the house, not in the front of the house, so it's away from the street. There's no evidence there's any windows in the home. There's no evidence that anybody used it. There's no evidence that the guests came through the cellar as a front doorway. And so we'd say certainly they took steps to protect it from observation. So in that situation, that certainly the cellar in this situation, based on the record, we can find as part of the curtilage. I would also argue that the Escalera case, which this court found to support a search warrant, found that a cellar in a three-family home is part of the curtilage. Now, the only exception difference between the Escalera and our case is only one tenant had use of the cellar, and there was a lock on the door. Leslie found that when you're dealing with curtilage, you don't have to have exclusive use by one tenant. If the tenants collectively use it in the same manner, it's still being part of the curtilage. Also regarding locks, the motion judge found no locks, but I direct the court to the cross-examination of Officer Mendez in that he said that there was a knob on the door, but he cannot say for sure lock or no lock. So we can't say for sure there's no locks. So I would strongly argue that the Escalera case is on point to show this cellar is part of the curtilage. When that happens, we find that the area is a constitution-protected area, and then we try to find whether or not there's any police intrusion into the area. If the police intrude into a curtilage, in the curtilage, which is a constitutionally protected area, police intrude in that area, it's deemed a search. If there's a physical intrusion in the curtilage or the cellar, it's deemed a search. I'd also argue that the side yard can be deemed part of the curtilage, given the Dunn factors. Here we
Counsel,
have-
can I
yes.
ask you one question about the Dunn factors,
Yes.
because you make mention of it in talking about the record? One of the things that struck me about this case was the rear of the home seemed to be a little bit different than you would have with the typical home. It seemed as if there were other residents, there were other homes behind number 14. That, if I remember correctly, there wasn't a fence between those, the dwelling behind there. It was the big open yard. Again, knowing that Dunn's not necessarily dispositive, doesn't that change the whole access part? Because there was evidence in the record that the door was ajar, whether or not the doorknob had a locking mechanism or not. If you couple that with the fact that it was a big open backyard that other folks used to access the rear dwellings behind number 14, doesn't that cut against you?
No, Your Honor, we're dealing with observation, not trespass. And I think the door leads down to a stairway and a long hallway. So we're dealing with the Dunn fact that deals with, can people observe into the cellar? That's the key question, Your Honor. So yes, there might be observation. The key thing is, was there such observation where you can look into the cellar? So the issue is more along the lines of not trespassing per se, but showing they took steps to exclude viewing from passerby. Now, I would say that the cellar door, there's no evidence that the cellar door was all windows, and you went down a flight of stairs into a long hallway. So I don't think the cellar could be viewed, based on the record, from the neighboring homes.
What is your legal authority for the proposition that it's about observation?
Well, the Leslie case, all the cases, the observation has to deal with, the Leslie case dealt with, they talked about fences, enclosures. They had recycling bins blocking the porch and whatnot. So the fourth Dunn factor deals with observation, whether or not a passerby can see into it, like a plain view, if you will. So the fourth Dunn factor deals with, can people...
I see, so you're focused on the fourth Dunn factor.
Yeah, I was answering Your Honor's question regarding that issue. If the area can be viewed easily, that cuts against the curtilage argument. But here it's...
But the curtilage argument really focuses on whether or not the area is intimately tied with activities that you would normally associate with the home.
Yes, you would, Your Honor. And regarding that, Your Honor, the nature of use, you have a situation where there's two laundry rooms. There's tables, there's chairs, there's benches, there's bureaus. There's a video itself, people being there to make videos. And so you can almost get, it's not really a man cave per se, but the cellar was used for laundry, which is everyday life. People do laundry all the time. There was table and chairs. Even the defendant's girlfriend says it's a public place.
What is the evidence of who had access to the cellar?
Well, the police indicated that they thought that all three tenants had access to the cellar. The police indicated that they thought, I think Officer Mendez indicated he thought the police had, that the three tenants had access to the cellar. That was the police's opinion. So the police, I don't know, I don't have a site, but the police indicated that. And so there's no evidence that the public at large came through there. It's not a front doorway. There's no evidence that the public at large came through the cellar to enter into the unit. Regarding the intrusion, police have a license to enter on the property, which is basically come on the property, ask questions, and leave, implied license, which is limited in scope, duration, and purpose. And here, there's no justification for the police to chase the individuals into the side yard, much less the cellar. So at a minimum, when they enter the cellar, they certainly overstep their license. You need justification. There's no justification. There's no probable cause here. There's no exigent circumstances here. So the entry into the cellar triggered the search. That's when it started. The search happened when they entered the cellar, based on the Leslie case. There's no justification here for the search. It's getting back to standing again, Your Honors. I'd like to say that several reasons why they're standing. He was present on the property. This entire event happened, the same transaction occurrence. He was still there when they searched the cellar. He was being held by one of the officers.
Counsel, could I interrupt you just because the one thing you said, I don't want your time to run out. You mentioned that you thought that there were no exigent circumstances here. You don't think that viewing that video where those firearms are depicted, localizing it to number 14, going there and seeing all of these folks dispersed, including a bunch, I forget the guy who's the account holder running around back and alighting down the stairs into the basement. You don't think that's Those are exigent circumstances?
I'm pretty sure, if you look, from my recollection of the record, Your Honor, they weren't sure where the firearm was. They didn't know.
No, I'm not saying that they did, but they say that a bunch of folks run down into the basement of number 14 where they knew that's where they were at. Doesn't that help?
No, Your Honor, they didn't know where the cellar was. They don't, in the Snapchat video, Officer Mendez, I'm pretty sure, check me on this, I almost positive he said, I don't know which cellar it was. So I don't think that is enough. And I think on the Warren case, I believe, flight is only one factor, but not itself going to show exigent circumstances. And I'd argue the Lexus case, that person retreated into the house. And so I'd argue that because he did not, I also believe say, probable cause before doing the surveillance. So I would not say that, Your Honor.
Okay, I'm sorry. Is that it? For that answer?
Yes.
Okay, I'm going to tell you that your time is up. Can I thank you?
Oh, thank you, Your Honor.
Okay, Attorney Stern.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. Your Honor, the Commonwealth takes the position that the appeals court reached the correct conclusions in its decision in this case regarding standing, which we argue is dispositive.
Do you agree, though, that their understanding of standing, where they said if they're present at the time of search, is not necessary to automatic standing?
I suppose it would be a rare circumstance in which a defendant.
Yeah, but I mean, I'm
yes.
just talking about our case law, what our
Yeah,
case
no,
law
yeah, the
says.
standard is if you're
you didn't
charged with
need to be
possession at
there.
the time of the search. So in
Yeah.
theory, if it's constructive possession through somebody else, then I imagine you would likely not need to be present. I think frequently.
I want to know where in the case law that popped up. I just am trying to find it. But
I
anyway.
actually had not thought about that, Your Honor.
Okay,
I'm
thanks.
sorry.
Never mind.
I've looked into many things, and but I could look into it if you want.
No.
I do think it would be a rare case in which you would be present and not be charged with possession at the time of the offense, and therefore, sort of from the perspective of, you would frequently be present. They would frequently merge,
right.
but that is true. I had not sort of.
Well, in Frazier, the defendant wasn't present at the time of the search of the handbag.
Well, again, there is, there's a lot of language specifically, I think, about, relative positions of co-defendants and constructive possession. I mean, for constructive possession, you don't need to be present.
Yeah,
So,
but
Frazier
I
wasn't
just
a
think-
constructive possession case, was it?
off the top of my head, unfortunately,
Yeah, just to refresh your recollection.
yes, thank you.
Frazier was a case where the defendant's girlfriend had a handbag that had the cocaine in it. She was in a donut store. He was in a car, and so he was arguing that he would have automatic standing because he was charged with a crime where possession was an element. So he was neither there at the time of the search, nor was he charged with possessing the cocaine at the time of the search either.
I don't, particularly with Frazier, I don't know, Your Honor. The language about at the time of the offense goes back to Jones. So it's not, and it was applied in Moore, albeit before the
The
adoption.
Jones, you're talking about U.S. Supreme Court
United
Jones?
States, yes.
Okay.
So it's not, it was not a belatedly added or sort of, I know what the source of that is, at least
Oh.
at that far back.
You mean you know the source of present at the time of search?
No, I know the source of at the time that charged with possession at the time of the search.
Okay, but that sent, well, never mind.
Yes,
I'll
no,
look at
but
it.
unfortunately, I cannot answer at the moment your question with
No
regard to
problem.
Frazier. I'm sorry. So,
Where are we now, particularly after Delgado, Rivera, where are we on standing then, on this automatic standing when you're not present?
I mean, Delgado Rivera says that Mubdi is within the context of somebody else related to the offense. So that does not by itself contain an element of presence. It does contain an element of limited world of people who can have a reasonable expectation of privacy. And the appeals court, I would argue, properly found that in this case, no one had a reasonable expectation of privacy in the basement, in this particular basement.
It doesn't, I mean, we've got a constructive possession case, right? based on a Snapchat video from the day before, is not present in the building when they find this is turning into like, it's turning into a mess, isn't it? I mean,
It's in a very unusual fact pattern, I would think. I would not think this would come up very often.
But I mean, I guess, isn't it important in a constructive possession case it's a video where three guys, right? The Snapchat video, people, do they change the firearm? Do they pass the same firearm, or are they all showing different firearms? I can't remember.
I think two people are holding this firearm, but the defendant is very clearly holding the firearm and dangling it as described in the video. So he's not, I don't think that the focus was on what the other people in the group were doing with the gun. And it was made, the Commonwealth, I mean, a lot of the theory behind automatic standing is that the Commonwealth can't have it both ways. You can't say, well, you didn't say you possessed it, so you can't challenge it, but you totally did possess it at the time, and we're going to prosecute you for it. Here, the Commonwealth was, I believe, clear at trial, and evidently clear at I don't think anyone ordered the transcript of the second motion hearing that was just argument, but Judge Dupuy finding that the Commonwealth had already committed that the possession was at the time of the video. And frankly, I don't know that we could have shown in any event possession at the time that this gun was found in a basement of a place the defendant didn't live. There's no evidence. We didn't allege that it was his gun. We didn't allege that it was his place. We alleged that there's video evidence. And so I think in that sense it's analogous to Mora, that there's evidence from, in that case, a witness, in this case, a video, that the defendant had the thing, but that...
But are we gutting, I mean, I'm not sure Mubdy made sense to begin with, but are we gutting this principle at this point where, it's a possession case, right? It's a constructive possession case, and now we're not giving him an ability to challenge it, right?
I wouldn't say it is a constructive possession case.
Well,
I think we might have, I think that on different facts it could have become if there was...
So it's a pure possession case because he's pictured in the video passing it around, yeah?
Well, that he is pictured posing with it in a fairly dramatic fashion that is intended to show his dominion and control over the gun. If he were just told, I mean, I guess you could argue, but I mean, possession of a firearm these days is, in general, having it at all. And in this case, that he was clearly intending to convey to the audience that he was in dominion and control over this gun.
Ms. Stern, I agree with you. These are unusual facts. But I'm trying to understand the rationale for standing in this circumstance, and if there is, whether we ever, or isn't, whether we even reach the issue of expectation of privacy. So if the point of automatic standing for possessory crimes is it's just unfair for a defendant and a co-defendant to have different dispositions, number one, how is that concept applicable to a search when the time of possession is not the time of the search? And there's no constructive possession argument, it's joint possession. Mm-hmm. And number two, if there isn't or is standing, mm-hmm. Do we necessarily in all circumstances nonetheless analyze expectation of privacy? Or does Mumdy stand for the position that if you have standing, then that's it, you can borrow anybody else's expectation of privacy?
Well, I read Delgado Rivera to read Mubdy to say that it has to be a relevant person's expectation of privacy. I think there is wisdom in that because insofar as suppression works as, I mean, obviously there could be a deterrent effect on police, but to allow a defendant to assert the rights of someone else who were violated only really makes sense as a remedy for the violation of the violated party's rights if the violated party shares the defendant's interest in suppression of the evidence. You know, if the you can imagine many people might be offended that police entered their property but would not feel that to find evidence of a crime that they didn't hypothetically know about on the property, but would not feel that it had solved the problem to have the person committing a crime on their property not be able to be prosecuted. They might have very different interests than the defendant. So I think that having a nexus between the rights violated and the actual suppression as a remedy for that makes a lot of sense.
I know that I'm interrupting you before you get to the rest of my question, but along those lines, what you're saying is as a prophylactic remedy, it makes no sense if the other individual's expectation of privacy has no connection to the person seeking suppression.
Yes, and insofar as they are, as noted in Delgado Rivera, as noted elsewhere, generally personal rights, that to say that a search in the constitutional sense occurred essentially requires some nexus to the person, between the person and the rights, and the rights are held by the people rather than the police. I mean, though homes are special, obviously, but with regard to the sort of the fairness element and automatic standing in this case, while I think you reach the standing before you reach reasonable expectation of privacy. Reasonable expectation of privacy informs why it's not an unreasonable result, because essentially, you know, if you post a Snapchat video on your friend's account, not even your Snapchat account, so you might not know who's following it, of you committing a crime, and you leave the evidence or the evidence stays under whatever circumstances in a basement that none of you have any known connection to, and you never assert one, you're sort of on notice that anything could happen to it.
Well,
as a practical matter.
Okay, so when you say they merge, I know this is a difficult question with our case law, but if you have standing because it's a possessory crime, is there a separate analysis that has to take place as to expectation of privacy?
It takes place if?
As to expectation of privacy.
I mean, I think well, first of all, it depends where one thinks Mubdi stands at this point.
Exactly.
But I know Justice Cipher in her Delgado Rivera concurrence was emphasizing the difference between automatic standing and automatic expectation of privacy. I mean, I think that they do. I mean, I think conceptually they remain different, but they do ultimately, if the expectation of privacy is somebody within the sort of the nexus of the offense, then the standing is likely to be in terms of constructive possession or other factors.
Would you put it this way? Could you say that if you have a reasonable expectation of privacy, you have standing, but that doesn't always mean that just because you have standing, you have a reasonable expectation of privacy?
That sounds reasonable to me, and certainly you have Fourth Amendment, you know, standing anyway. So, or whatever you want to call it. So at that point, you have your legal sort of ground. So it makes sense for Massachusetts.
What you mean by that is that the United States Constitution provides a bottom of protection.
It provides what?
A bottom, a minimum of protection.
Yes. So in that sense, you would already have, colloquially speaking, standing without the standing element. And get your motion to suppress, be able to challenge the seizure of that evidence.
Can I ask, are you done? So Leslie, how do we square Leslie with there's no search here? How do the police get into this basement? What are their grounds for running into somebody's basement? And just because it's a multi-family home, they can run into that basement?
Well, I think that first of all, I think the question of can the police do it and who has standing to contest the fact that they did it are different.
I get it. It's complicated. Who do we, from this record, know who's the different families? Are any of them involved in this?
No, there's no evidence of how they felt about any of that. There was evidence that one person who was out with the crowd but was not involved in the offense had a girlfriend in the apartment. Right. The defendant's girlfriend called as a witness, who didn't live there, called as a witness for the defense, named some people that she thought had lived there once that she vaguely recalled things about, but they have never weighed in for, we have no idea how they felt about any of this, the police or the guns.
Leslie kind of rewrites a little bit of this and says, okay, we're not going to treat people who live in multifamily homes differently than rich people who have their own house. So isn't this a search of that basement? I understand we got a whole lot of standing stuff to sort out, but I don't see how the police get to run into that house.
Well, to give a slightly complicated answer to a complicated question, well, first of all, I mean, again, there are all sorts of situations that the law recognizes where whether whether the exclusionary rule is a remedy does not turn on whether you could do it going forward. I mean, the police could walk into anyone's house, look around to be nosy, sees no evidence and leave, and you can't exclude anything because they didn't try to prosecute.
But they came out.
Something
with-
else stops them
They
from doing
came out with the gun here.
What?
They came out with the gun here.
Yes, no, I mean, I agree. I'm
And
just
they
saying that-
ran into the house.
Yeah.
What grounds do they have to run into that house? Forget about
Yeah.
whether, if this were just one person's home and that door was open in the basement, as most of us leave our
Yeah.
outer doors to that kind of stuff open. So,
But
go
I-
ahead. So how do they run in? I'm confused. Why do they get to run in there and rummage around?
Well, again, to make two different points. One is, we're not resting on the legitimacy of what they did here. I think there is evidence that they weren't trying to do anything surreptitious. They were chasing people they thought had
I
guns
know,
on
but
possibly
this
insufficient
is your house.
inferences.
This is your house and you've left your back door open.
Yeah.
They don't get to run into that house, do they?
Certainly not in the usual course of things, no.
Just because you got a bunch of kids running out and
Yeah.
around in the back, you also don't get to run into the house, right?
Yes, but once they were there, the
Once
question, I
I
mean,
don't care. Why do they get to, I mean, do they
I'm
get-
not necessarily arguing that they do get to at
okay,
this
but
point.
so then this case is gonna rise or fall on the standing issue?
Yes, Your Honor. And I mean, again, the standing and the existence of rights to challenge the search in the people implicated by the search. Because again, we don't know whether the residents, what they considered to be the greater and lesser evils here. We don't know how they felt about it. We don't know if they thought that offense, I mean, there's a lot going on. I think that Leslie informs the general issue of how to assert recognizing that if there are attempts to assert curtilage, reasonable expectation
Can I
of
ask
privacy.
one other question? Because again, I find this really difficult, and maybe I just don't understand it. But, so we've got the Snapchat video. And the gun in the Snapchat is distinctive enough. There's no issue about whether this gun they found is the same gun in the Snapchat video. Because I'm caught up in the fact that this seems odd.
If
That
you-
he's being charged for the Snapchat one, but he can't challenge that because he doesn't have standing on his friend's Snapchat. Or he doesn't
Yeah.
have a reasonable expectation
Yeah,
in that.
I mean, that's a whole
But then-
other issue that I,
Right, and they're running into the home and taking out this gun. They have no right to go in there as far as I can figure out. Then that gun is being matched to the other one. There are a lot of things are held together here by some very good luring by you, I think.
well, again, I mean, sort of to touch on the target standing general idea that my brother brought up, that I think it is important that they were not doing all of this as a pretense to get into the basement because they thought there was a gun there. It seems like they were expecting the guns on the named people.
That's assumed you can go in. Forget about pretense.
Yeah.
If
I
I'm
just wanted
right,
to
they
make that.
can't run in there. Doesn't matter whether they're doing it on a pretense or not. I mean, Justice George may be right. There may be some kind of exigency, but it's not obvious to me. But
Well, again, I think it comes down to, I mean, there's a difference between whether anybody has the sort of reasonable expectation of privacy that even under how the appeals court construed Mubdi and whether the police actually can walk in, that the things that keep the police from walking into single family, I mean, again, that the exclusionary rule is not the be-all and end-all of things the police can do. And that I think that ultimately there are a number of practical checks on what anybody's ability to wander into basements that are not, and the law does not solely turn on that. I mean, and just with regard to, the relative rights of people of different financial abilities, there were parts of this basement that were secured that clearly had people's personal property. There were parts that were open. The backyard did not have a fence. It was facing people's front doors. There's a lot of ways that you can demonstrate an expectation of privacy or the existence of the intimacies of the home in a multifamily dwelling that would not exist in every basement, in every yard. And I think it would, as this has always been, be a fact-specific determination about that, and it would not be unreasonable to conclude that this particular basement, the open areas, which frankly was full of people with no known connection to the house, but also all of the other information about it, that there was not a reasonable expectation of privacy in the conventional sense held by anybody in the house, but also more particularly anybody who had any investment in the gun that was there by itself.
Does anyone have any other questions? Okay, thank you so much.
Thank you, Your Honors.